found to another way of making the other submissions that he made, to the effect the judge just should have found that the claimants had different suitability requirements from the ones the judge actually found. But as I've said before, the judge had all the material he needed to make the findings he did on suitability. The next is my learned friend's ground 5.3.3. This is a point about the structure of the product. Now, the claimant's requirements, as found by the judge, were for a product where the coupon would pay the interest on the lending for the product, where the capital was protected so that the principal on lending would be repaid at maturity with the prospect of a return. That's what the judge found in paragraph 76 of the judgment and repeats at 300. What my learned friend did was to go on quite an elaborate expedition into whether the coupon should be treated as a return of capital, or could be viewed as a return of capital. Now, as it happened, that was at odds with the term sheet, which talked about interest, and although Dr. Fitzgerald gave evidence on this, it didn't really survive his cross-examination, and I'll come to that in a minute. But in any event, the point was a moot. It didn't take my learned friend anywhere. Because what the judge is saying is the requirement is to have all the capital protected at maturity, have the 100% of capital at maturity, as well as the coupon or interest, call it what you like, as well as the prospect of a return. So it doesn't matter what you call the coupon, or whether you call it a return of capital, if you're not getting your capital at maturity, your 100% capital at maturity, which is what the judge found was the requirement. And my learned friend ignores paragraphs 76 and 300 of the judgment. It's worth just picking up 300 of the judgment. Put shortly, the right notes did not meet the requirements of Mr. Khorafi and Mrs. Hamad that the investments provide 100% capital protection so that the ABK loans could be repaid, and the income stream which would service the interest payments due in respect to the ABK loans. And the same point appears from paragraph 76. So this submission was a red herring. It doesn't matter, the academic debate about whether you call the coupons on this product a return of capital. Now, in any event, the judge's analysis of the investment structure was, in fact, fair. There was no protection of the capital if part of the guaranteed amount was paid out to meet the interest instalments on lending. Absent growth on this product, there wouldn't be the capital available at maturity to meet the principal. And there wouldn't be obviously any return on top, because you'd first have to meet the very substantial shortfall on the principal. So that is what immediately gave rise to the risk of the claimants not being in a position to repay principal in circumstances where they required no risk, as we've seen. And the judge conducted his analysis of the product, which is just part of his judgment, at paragraph 49 of his judgment. My learned friend went to that paragraph, but paragraph 49 and paragraph 83 did fairly describe the product and its flaws, looked at as a matter of substance, and in the context of the claimant's requirements. And the suggestion that the judge in some way didn't understand the product is, in my submission, quite untenable. The judge plainly understood the product, and he explained clearly why the product didn't meet the requirements as he had found them. On this area, my learned friend went to Dr. Fitzgerald's report, and as I heard him, he appeared to be trying to derive three propositions from Dr. Fitzgerald's report, all of which just didn't work or didn't take him anywhere on the evidence. The first proposition from Dr. Fitzgerald was that the product was not, in fact, particularly risky. This was exploded at trial by Dr. Walford. The evidence on that from Dr. Walford was set out in paragraphs 352 and 353 of the judgment, where paragraph 352 Dr. Walford set out the serious risks that arose in relation to this product, including, I should say, the risks that eventuated in this case, which some are set out at 3, 4 and 5, and indeed 6. And 2. And indeed 1, because in the end, because of the other risks leading to the collapse of the product, there wasn't any guarantee of coupon either. So every single one of these risks eventuated in this case. And at paragraph 353, Dr. Walford explained about the product being, or the summary is from a judge of Dr. Walford's explanation about the product being doomed to failure, and likely to lead to losses even in normal market conditions. And then at paragraph 354, the judge records our submissions on the basis of Dr. Walford's report, and at paragraph 355, the judge accepts those submissions. The second proposition my learned friend appeared to be deriving from Dr. Fitzgerald was that you couldn't conceivably get products of the kind that the claimants wanted and say they were promised. It is, I've already dealt with that, I'm not going to spend any time on it, but it is worth noting that Dr. Fitzgerald accepted in cross-examination that you could, in fact, for example, in a product based on a high-yield bond, get all the features the claimants wanted, although, of course, there'd be a question of issuer risk. Now, I'm not suggesting that that sort of product would, in fact, be suitable for these requirements, and I'm not suggesting that sort of product would be available without issuer risk. But the idea that what was wanted was so outlandish that no one, especially no unsophisticated investor like the claimants, could possibly have understood that that was being offered, just doesn't wash.
And then again, the cross-reference to
yeah, well, yes, the reference is at day 8, which will be D2, tab 58, at page 176 to 178. Yeah. The third point from a learned friend summary of Dr. Fitzgerald was the point about coupons and capital, and as I've said, that's a red herring. But for what it's worth, Dr. Fitzgerald's evidence on that point was highly unimpressive and unsatisfactory, as one can see from the judge's interventions in the cross-examination. And the reference is again day 8, pages 183 to 187.
Were you tying that up?
Well, I think your hands.
I'm just asking.
No, I wasn't going to, but I'm happy to if
No,
my Lord wants to see it.
You must take your own course.
I'm thinking about time, really. The next ground for my learned friend was ground 5.3.5, and the argument is that the judge should have found that if they were suitable for Mr. Khorafi, the products were suitable for all the claimants. Now, again, this doesn't arise because the judge found that the products weren't suitable for any of the claimants. But even so, the rules do require the firm to assess suitability by reference to the client. It must treat each client as its client for the purposes of the rules, including suitability. My learned friend refers in this case again to the Zaid or Zaki case, but that was an English case decided under different rules, and in that case, the clients had a joint account, as I said yesterday, and the person who mainly dealt with the firm had authority to transact without consulting the others. So it's completely different to this situation. The next point raised by my learned friend was the DFSA complaint point again, which, as I've said before, is a bad point. My Lord, just looking at my notes, I think I have got time to go back to that transcript reference, so can I just do it? Because it's quite useful for my Lords to see. It was about a D2 tab 8. Sorry, tab 58. And the first reference I gave my Lords was at 176 to 178. Well, it really starts at 177.
Is there, I'm sorry, is there an index of who was called and when? I mean, you can always look at the back of these.
Yeah.
I don't know why they always put it at the back. But
I don't
at
think
the
there
back,
is.
at the back, last page of all these transcripts, you always have the,
Yes.
I call the index.
I don't
If you
think there
really
is.
want, there's a contents page at the front.
That could be produced. And it would have, that could be produced. It would have helped me when I was preparing this
I'm
appeal.
sure it would. That's what I did if I seem to remember when faced with a great volume of transcripts. I try and create my own contents, but I would be grateful for a document which simply says
Yes.
X in chief,
Yes.
divided 53 page so and so
Yes.
to so and so, your cross-examination.
Yes.
So
That's,
and so to so
that's
and so.
easily done.
Thank you very much.
Hopefully, unlike the other schedules, couldn't be the point of any controversy. We'll see.
Thank you.
So, my Lord, it starts at page 177. I ask if I can move on to paragraph 217, just remind yourself of the high yield bond in 2007, but obviously given the investor interest on top of that principal, potentially enough interest to give a return on top of any borrowing. That's correct, isn't it? Answer yes. Perfectly possible for an investor, and particularly an unsophisticated investor, to think that a structured note would be achievable with all of those things. Answer, again, it relates to who the issuer is. I'm very happy to agree with you. If you go and want to buy a bond, you can find German bonds paying 1 and Greek bonds paying 9 and so on. Question, based on a bond of that kind, you could do all the things that the claimant's cases they wanted and expected out of these products. In other words, you could have got a capital guarantee, or if you like, or your principal back, plus interest to pay borrowings, plus a return on top. Answer, yes, if they're willing to take the level of issuer risk for such bonds, absolutely. Question, another thing you could have done, again theoretically, is take, let's say it's quite a high yield bond and there's quite a lot of yield above your cost of borrowing, that element of yield and turn it into some kind of derivative to get some sort of option on the market, on the equity market in theory. Answer, I'd agree that, for example, if you invested in a 15% bond and you borrow at 7, then you could use the extra 8 if the issuer didn't go bust in the meantime to do anything you like, including buying equity options or whatever. You could obviously structure a product that did all of that. Answer, with that issuer credit. So that was that reference, and the other reference I gave you is just on the next page, starting at page 183. And perhaps without me reading it, I would invite my Lords just to quickly read paragraphs 183 and then the rest of that page, and then going over to 186. And one can see how the argument ran, and the judge's surprise, rightly, in my submission, at Dr. Fitzgerald's treatment of interest and capital.
So let me just read it.
It goes on to 187. Well, it was in my submission, perhaps unsurprising, that the judge found he derived little assistance from Dr. Fitzgerald. That's recorded in paragraph 351 of the judgment, and it's fair to point out, as I think my learned friend says, that what the judge is dealing with there is the disclosure of risks and suitability side of the case. But what the judge says is, it was perhaps unsurprising I obtained little assistance from Dr. Fitzgerald's evidence in relation to the extent to which an authorised firm in the position of Sarasin-Alpen, exercising reasonable skill and care, could have expected to draw those risks to the attention of the claimants and advise upon them. So it's quite a wide finding from a judge about his being not assisted by Dr. Fitzgerald evidence. One of Dr. Fitzgerald's problems, as the judge recorded in that paragraph, was that although he was purporting to give advice in relation to suitability, that was what the purpose of the report was, he had no experience of selling products to retail customers. So he was simply not an expert in the relevant area at all. All his business experience was of trading with hedge funds and wholesale customers and the like. Now, the next ground of attack is my learned friend's ground 6, which is a series of grounds attacking the judge's decision on that the breaches of the rules were intentional in the case of a client breach and reckless in the case of a suitability breach. In my submission, this is another unrealistic challenge. First, this is another moot in my submission, in that it doesn't get my learned friend anywhere, because even if the failure was negligent, Article 94 was still engaged. Now, my learned friend suggests for the first time at this hearing that we can't make that point because there isn't a respondent's notice at making that point. Now, we don't need a respondent's notice. And the reason we don't need a respondent's notice is that the judge has made a finding of intention and recklessness. The finding of that greater mental element automatically and ex hypothesi encompasses a finding of the lesser mental element. So, at best for my learned friend, the Court of Appeal would simply be disturbing the judgment to the extent of adjusting out the higher mental element of intentional recklessness and knocking that back a bit to recklessness or negligence, as the case may be. But what it's knocking it back to is a finding inherent in what the judge has already found. So we're not trying to uphold the judge on a different point or saying the judge was wrong in some respects and should have been doing something else, and all the usual material for respondent's notice. We're saying the judgment should be upheld, and it should be upheld because it's inherent in his judgment that he's already made a finding of negligence, and we don't need a respondent's notice for that. Now, my learned friend...
Well, Mr. Bindle says that negligence doesn't mean negligence, it means gross negligence.
That's the next point. I'm not sure why he says that. Article 94 just says negligence. There's no basis I'm aware of for construing negligence to be gross negligence.
He said they're just as generous, didn't he? He said that it takes its character from the two previous categories.
I'm grateful. I didn't hear that, or I missed that. Well, it doesn't. Intention is different from recklessness. Negligence is different from recklessness and intention. They are a scale, and there's no reason to read negligence as meaning anything other than negligence as ordinarily defined. Negligence is a concept used elsewhere under the DIFC laws, and where it's used as negligence, it means negligence. I should say, if it mattered, gross negligence would, on the basis of the judgment, gross negligence would again be established on the judge's findings. So it's another moot. But there isn't any test of gross negligence, and the statute would have said so if it had meant that, and probably would have needed to define gross negligence, because, as we all know, gross negligence is not, in many legal systems, a recognised concept, and certainly under English law, and would usually need to be defined, so one knows what one means. Now, so as I say, this whole area of challenge is a bit of a moot, but in any event, the findings both of intention and recklessness were sound and should not be disturbed. In relation to the client claim, where the finding was intention, I've been through the material in some detail. We list some of it at paragraphs 368 and 369 of our skeleton, but just to run through a few of the points, the claimant's forms had been filled in with false information, which was deceptive and purported to have been put in by the claimant. And that was a deceptive document put in as a substitute for a process of analysis, which the claimant should have done, and on the judge's findings did not do. Next, the false information had been wrongly relied on to try to defeat the claims. There was no reliable explanation as to how the false information came to be put in. Saracen should have had records of its processes, but it didn't have them. Client information on Saracen's own documents, as the client profiles, was itself wrong. And all of this made the judge entirely justified, including that there was an intentional rule breach. But as I say, even if he hadn't, he would have found it negligent. The suggestion he wouldn't have found it negligent or reckless is untenable. Malone Friend sought to suggest in his submissions on the facts on this point that Mr. Walia had said to the judge that this information in the client forms in the ATBCs was based at information given by the clients from meetings he was at. But the problem with that is that the judge, Mr. Walia, in fact said a lot of different and contradictory things. And the position as found by the judge was that Mr. Walia could only speculate as to how the basis on which the information was filled in. And that is recorded in judgments paragraphs 188 and 189. And one also needs to keep in mind just how false the information was. It's not as if this was essentially true information. This was wildly false information. For instance, the suggestion that Mrs. Rifai had over 200 million in assets. Likewise, in relation to suitability, the judge found that in the light of Mr. Walia's evidence, the rule breach was reckless. That was a conclusion he was entitled to reach, having heard Mr. Walia's evidence. The substance of Mr. Walia's evidence made it clear that Sarasin-Alpen didn't concern themselves with suitability, even though, on the facts of this case, they were advising on the merits of the investments and making recommendations. And it's no good for Mr. Walia to have said, as he did, that he was just relying on them giving generic advice, because he and Mr. Nair, who were the main people conducting this relationship, were themselves involved in puffing the merits of the investments and giving the recommendations. So it's not as if you can say there was some junior person in my office who should have been giving generic advice, but actually he may have overstepped the mark. The core of the business being conducted here consisted of non-generic advice and recommendations, as the judge has found, and that was being done by the people at the very top of the business and the people who were conducting the whole relationship. And one of the problems with the product, for example, was that it put, as I've said, the second claimant in immediate breach of its commitments to ABK, which is a $20 million problem.
Sorry, could you say that?
Sorry. One of the problems, I was just giving you an example, one of the problems with the product was that it put the second claimant in immediate breach of its commitments to ABK. That's the $20 million problem. Now, that's just one example, and the judge was entitled to find the claimants were reckless in relation to suitability. Sorry, the defendants were reckless, and first defendant was reckless in relation to suitability. And in any event, as I say, it's untenable to suggest that the judge didn't have solid grounds for his implicit finding they were negligent. Well, that's ground 6. Ground 7 is my learned friend's criticism of the judge's finding that the failure to meet the margin calls didn't break the chain of causation. That was another factual finding for the judge and not open to challenge. We've set out the timeline at paragraphs 375 to 380. And my learned friend makes great play of the fact that there was an original margin call at the end of September, and the suggestion is, well, they had lots of time to meet it. But of course, what they had was a deadline until, I think, 17th of October, and then on the 8th of October, that deadline was shortened, and they were only given a few hours to meet the deadline. I'll just take my orders to the margin call document. It's in bundle H3. It's H3209B. This was an email sent at 8:20 p.m. on the, I should have said 7th of October, not the 8th, the 7th of October, 8:20 p.m. So at that point, they thought they had until 17th of October, but they're told at 8:20 p.m. here's a new margin call, and the margin call itself requires the margin to be met, you can see over the page, to our satisfaction by 8th of October, it's the following day, 12 o'clock Swiss time, noon.
So this is a dispatch at 8:20 p.m. Dubai time, is it?
We don't know. I don't think one can tell for sure, because it depends who printed this. I think it depends which recipient printed this, because the recipient, depending on where they are, will be recording their time. So one can't tell.
Right. Well, it's addressed to Mr. Khorafi.
No, but this could have been printed by any recipient, or indeed, I don't think.
Well, I agree, but the only recipients they're all in the Middle East, right? Well,
I think this document is our disclosure, so
Right.
it's probably printed by
Yeah.
us.
So yeah, I think probably it's fair to say it's probable, but not certain, that it's this time zone. But one doesn't know. One doesn't know.
Right, okay, well, we're only talking about 2 or 3 hours.
Yes.
Okay, right.
And then
So that's 12 midday on in Switzerland.
midday in Switzerland the following day. So that's how long they've got.
Yeah.
And the judge fairly reached the conclusion at paragraph 314 of his judgment that he was not satisfied that the claimants could have met the margin calls in the time available. That was an issue explored with the witnesses in cross-examination, and the judge was entitled to reach the findings he did. My learned friend suggests the judge should have given more consideration to the possibility of transferring securities, but the judge had that well in mind, because he records that point at paragraph 311 of his judgment. So he's well aware that the margin didn't just have to be met in cash, because he records that. And he nevertheless makes the finding at 314 that he's not satisfied they could have met the margin call. And I should say that the idea that the margin call could have been met in this very short time frame, this very short time frame, particularly given that the claimant's most substantial holdings of shares were in unlisted Kuwaiti companies and the like, it is just an absurd proposition. Likewise, the proposition that a guarantee could have been negotiated within the few hours that the claimants had. And it's a mark in my submission of the desperation of this point that in their paragraph 155.1 and footnote 25, the claimants pray and aid a recent reference in these proceedings to the second claimant's wealth, which is a reference which includes her real property assets. So my learned friends really are clutching at straws, and the judge's conclusion that he was not satisfied the claimant could have met the margin calls in a short window was fully justified. My learned friend on this area next tried to rely on the fact that in July and August, before the official margin calls, there were already problems on the accounts. But that, again, didn't really take him anywhere. We have never disputed that the parties were arguing about the accounts in the summer of 2008 before the formal margin calls. Again, the judge had that in mind, and he refers to that in his judgment in paragraphs 157 and 158. In this context, my learned friend went to the HSBC note of that meeting, and that was quite an illuminating document in my submission. What it showed was it was a contemporaneous document supporting the claimant's case in this litigation, that they had been missold, and indeed that document records at the time an apology from the Sarasin-Alpen side, one that wasn't repeated.
Just give me the reference, would you?
Well, yes, it's an H3.
H3. I never looked at it, it's just...
Well, we have. 207.
207.
H3 207. Now, my Lord Sir David Steele made the point to my learned friend that there must be a limit once you've been sold a pup to the extent you need to keep throwing good money after bad. And that was a very good point, because even if one could have concluded that the claimants might have been able to meet the margin call in this very compressed time frame, my Lord's point independently supports the judge's conclusion that the failure to meet the margin calls didn't break the chain of causation.
And maybe more a mitigation point, that you can't be called upon to embark on unreasonable conduct by way of mitigation.
My Lord, yes. I think as my learned friend Mr. Brindle says, the causation and mitigation doctrines do rather overlap. It's causation and or mitigation.
And the criteria is what that the new cause must obliterate the old cause. Is that the right test? There are some judgments to that effect.
It is. I think it is a test to that effect.
Yeah.
It's perhaps in this context that one should consider Mr. Khorafi's email that my learned friend relied on. That was an email sent after the first margin call on 29th of September saying, "What do I do?" Well, so what? It doesn't affect either of these points. It doesn't affect the fact that the later margin call compressed the deadline anyway, and it doesn't affect the point that my Lord Sir David Steele raised. But one doesn't need that second point, because the judge's findings on the first point should be undisturbed in my submission. The next argument from my learned friend was that the reason margin was called had nothing to do with the mis-selling in this case, so they're completely separate problems. That could not, in my submission, be more wrong. One needs to remember paragraph 301 of the judgment. The judge's finding is that at the bottom of that paragraph, the potential for margin call posed the additional risk that the notes would not be allowed to run to maturity. That's the last point. Immediately above that, where he says first, the irrevocable payment order in favour of ABK made it impossible to use the coupon payments with respect to those notes to service the Bank Sarasin loan. And then at paragraph 302, the judge finds the problem with the cross-pledge. And indeed, even at para 300, the judge makes the point there needed to be a guarantee that the capital, the interest could be paid on as they went along, and all the capital paid on maturity. Now, none of those happened. All of those are jeopardised by the margin call. The margin call is precisely the problem the judge identifies at the bottom of page 300, paragraph 301. The reason the margin call has come about is in part because of the 20 million that had to be paid, which is precisely the problem the judge identifies in the previous point in paragraph 301. The reason C3 is on the hook for the margin call is because of the cross-pledge, which is precisely the problem the judge identifies at paragraph 302. And the net result of it all is that the claimant didn't have a guaranteed product that would necessarily keep paying the interest to ABK and pay the principal on maturity. And that led, parallel to all of his litigation and parallel to everything that's been going on in this court, to a continuing problem that the claimants have had with ABK. That's the background to all of this, is there's a hard-fought battle involving enforcement of security over their properties and the like, all of which, again, the learned judge was well aware of. Now, my learned friend next made the point that this was all about extraordinary market conditions and Liban and so on. Well, that doesn't work either. First, the risk, as I've just said, was the very risk that the judge had said in his judgment rendered the products unsuitable, margin calls, lack of capital protection, etc. Secondly, if you look at the collateral analysis that we provided in the appendix 2 to our skeleton, so A2 tab 8C, sorry, tab 8C. I'm afraid this is a document that is a little bit frightening to look at.
You say appendix 2?
Appendix 2 of our skeleton.
Yeah, I got that.
It says margin calculations. What we've done is shown the sort of shortfalls that one got at various times. On collateral, as either it was or at least could have been on the defendant's rationale calculated. There's obviously an element of discretion on the bank's part about whether it's going to call margins. There was also some opacity on the case about what margin they were entitled to call. This is a point which we explored with a judge and hasn't really been developed in this appeal. But in fact, on the defendant's own security documents, the agreement in respect of margin was in respect of agreed or customary margin. And there wasn't any evidence of customary margin, and there wasn't any evidence of agreed margin. So it left the whole margin question, in fact, rather up in the air. But certainly the defendants took the position they were entitled to call margin, and they appear to have adopted a 95% approach in terms of the haircut. Just for reference to customary agreed margin, it's at tab H1, tab 125, it's a pledge agreement there, H1, tab 125, page 6403, paragraph 5 of the pledge agreement. So again, this is the sort of point which we can't develop in this appeal, but it's certainly a point the judge is alive to. But back on my appendix 8, looking at the approach, appendix 2, looking at the approach the defendants considered they, at least theoretically, could have taken, one sees on, for instance, paragraphs 11 and 12 and 13, some quite substantial shortfalls. And the actual margin call that was made in October 2008 wasn't, in fact, especially significant by reference to other calls, by reference to other collateral shortfalls in this case. So it's not as if everything was going along swimmingly and then suddenly Lehman happened. There was always a potential, and indeed, in some cases, actual collateral shortfall, depending on the approach the defendants chose to take. It just so happened that when Lehman came along, they obviously got a lot more concerned about margin call, and they made their accelerated demand on the 7th or 8th. That's something they could always have done. The next point from my learned friend was another causation argument, challenging the judge's findings at paragraph 312 and 313 to the effect that the claimants would not have invested in the same or similar notes elsewhere if differently advised. This was again a pure question of fact for the judge, and on analysis, my learned friend's submissions again all depend on their argument that the judge should have found the investment requirements for the claimants were different from the ones that he actually found. On this point, my learned friend has a quibble about whether the judge was right to make the point he made at the post-judgment stage, that it was not a case of the claimants taking their money elsewhere because they had to borrow the money even for the first tranche. Well, the judge was right on that point. This isn't a case where the claimant had money to park. They had to borrow money to make the investment, and they did not do so, didn't borrow until they had agreed the investment and were committing to that particular investment, and that happened on the basis of their requirements, the promises made to them, which the judge found. The next point was a further point taken on whether the losses were too remote. Again, on this point, the judge awarded the claimants all their losses on the sale of the investments. There's no remoteness problem. The claimants wanted no risk. They wanted 100% capital guaranteed investments, and as I've explained by reference to the judgment, the losses flowed directly from the problems the judge identified with the product. I should say I don't accept the question of remoteness arises in relation to Article 94, which deals with questions of compensation. The next point was my learned friend's ground 7.4, which is some rather unsubstantiated allegations about what Mr. Khorafi might really have wanted out of these products. And the point made is that Mr. Khorafi was overextending himself and wanted to gear up as much as possible and the like. But the judge had that submission well in mind. He recalls it at paragraph 431 of the judgment. And he decided the issue squarely on the facts as he found. And the facts as he found was that the claimants had the requirements that he found, and that these requirements couldn't be met by the products or any similar products. And 431 was right at the end of the judgment. He says, it is said Mr. Khorafi was well aware of this, not satisfied the range of separate that and wanted to leverage that as fund his grandiose plans to participate in global markets. That's exactly the point my learned friend repeated to my lords. And the judge doesn't accept that and makes the findings on the basis of the findings, of the facts as he found them. Well, the next point I'm going to take in about 1 minute because it's quantum, which I appreciate and I fully accept has now been parked. I do just want to put up a marker. It's just worth my Lords knowing that the quantum appeal really could never get my learned friends anywhere. There was an agreed figure of 10.4 million, not a maximum possible claim, as my learned friend said. It was agreed, and the reference is in this D2's closing skeleton argument at C2, tab 29, page 848. And you don't need to turn it up, it's his Schedule Y, which in closings was common ground between all defendants, represented the agreed loss. I'm not suggesting they agreed questions of causation and the like, they weren't. But questions of quantification on the losses on the investments were agreed. The judge dealt with that very clearly in his post-hearing judgment, which, my Lord, you will find at bundle A1, tab 2. Paragraph 3. Through to 8. So the judge made a finding that there was an agreed sum which he was awarding there and then. And it's impossible to see what the grounds were. I mean, leaving aside the letter of causation points that are being dealt with in this hearing, it's impossible to see what possible ground there could be for challenging that 10.4 million.
Well, I know he doesn't actually identify the derivation of that figure, does he?
Well, paragraph 2.
Oh, sorry, I started at
Yes,
paragraph
I'm sorry, I
3,
should have
which
perhaps
explains why I was
paragraph
worried now.
So,
Yeah, well, there we are.
well, I know, I appreciate
I
it.
don't think he does. But
Well, there we are. It's parked anyway, but my marker is that for the next hearing there's nothing in this. The next ground, my Lord, is the breach of contract case. My learned friend's appeals here, on the whole, do not involve points of any substance that aren't repetitions of points I've already dealt with. And there are two exceptions to this. The first is that the judge's conclusion about there being an implied term, as he found in paragraphs 331 to 333 of his judgment, was in some way wrong. Now, I'm not sure that was pursued orally by my learned friend. I don't know if it's still pursued, but the provision of advice and recommendations obviously had to be carried out with reasonable skill and care. The defendant's only point on analysis seems to be that D1 didn't in fact give advice or make recommendations, but it did as the judge has found, and in giving that advice it had to be done with reasonable skill and care. So that's that first point. The second point is the judge's findings on this question in relation to 2.6.5 of the AGBCs. That's the exclusion clause. Again, it's worth turning those up.
What we're looking at the AGBC.
AGBC. So it's H1, 121 is a good place to see them. I'm not sure where the most legible version is. 122, my learned friend suggests is easier to read. The clause reads, the client acknowledges and agrees that to the extent permitted by law and the DFSA rules, neither BSA nor any other member of the Saracen group shall be responsible for any loss or damage suffered by the client as a result of A, any advice or recommendation given under these additional general business conditions, including without limitation any adverse tax consequences, or B, the receipt and passing on of any instructions or offers in respect of any investment, including without limitation losses arising from delays, losses, errors, mutilation, duplication or similar occurrences in the transmission or transportation of instructions or orders. Now, the judge dealt with this at paragraphs 345 and 346 of his judgment. And perhaps, could I invite my lords to read, in fact, from remind ourselves first of 343 and then 345. Yeah. So, well, the starting point is that we were submitting to the judge that it's a very curious clause, because either it just isn't effective to exclude any legal liability, because the words "to the extent permitted by law" and DFSA rules you just read as meaning if you're legally liable, then you're not excluding it, or if you reject that, this is the widest possible exclusion clause. It excludes everything. And as we said, there's authority that exclusion clauses should generally be construed in a manner which does not cover negligence, and that must be especially so when you have a contract involving advice and recommendations. To suggest that in a contract involving advice and recommendations, which are expressly mentioned in the clause, you can exclude liability for giving negligent advice and recommendations is most extraordinary. And obviously there's a point on the unfair contract terms rule, which we referred to as the judge records. But even before you get to the unfair contract term, as a matter of construction, you are not going to construe this clause so as to exclude liability for negligence in respect of advice and recommendations which are at the heart of this contract. Now, the judge deals with this at paragraph 340.